Brian Padayachee is the one answering the questions, and he is running out of answers. The IDAC investigator, whose affidavit put 7 senior police officials under arrest, including crime intelligence boss General Kumalo and a civilian appointed as a brigadier, sat before the commission and watched his own case get pulled apart line by line. The panel he flagged as irregular, approved by head office, he concedes it. The interview marks he says were manipulated, 40% for one insider, 49% for another. He admits he doesn't even know what mechatronics is. The charge sheets claim that she got a security clearance she wasn't qualified for. That's actually incorrect, his words. She was arrested before her 6-month vetting window had even expired. Then a commissioner leans in and delivers the line no investigator wants on record. You made it up. It speaks to an abuse of your power and authority to victimize an innocent person. He admits he showed a case file to his own witness. He admits that if he claimed the prosecutor checked the charge sheet with him, I'll be lying. And a high court has already struck down a bail condition with his own name written into it as arbitrary. If this is how warrants get issued, in one commissioner's words, I worry for the rest of the citizenry. Like this video, subscribe and hit the bell. Let's go inside.
Colonel, in your affidavit where you applied for warrants of arrest, you took issue with the constitution of the panel. IDAC inserted itself in the panel process, and IDAC said, why was Khan not put in the kernel? Why was so-and-so put in the kernel and not General Khan? Why does IDAC have that difficulty? Why is it IDAC's business who should or should not be in the panel that interviews at crime intelligence? Why is it IDAC's business?
Can I respond?
Yes.
Thank you, Chair. Thank you, Commissioner. Sorry, Commissioner, I thought you were raising your hand. We are charged with an investigation. And we draw that inference from the investigation that we're charged with. So when you look at the panel is recommended by Kumalo, it's chosen by him there. Although he does, that's what we are speaking to. The panel is not chosen by anybody else at that office. Like, who can we say?
No, we know who chose it.
He chose the panel.
The problem is,
so
yes.
What we are saying there is that he chose that particular panel and sent it for recommendation, and it was approved. And the issue we have there with it is that there was other crime intelligence generals that he could have used to sit on the panel, because it's a sensitive crime intelligence post. It's a covert post.
But is that not for General Nkua and General Sibia to say, I'm not happy with this panel or I'm happy with it? If they are happy with it and they approve it, what business is it of IDAC to say, we would have preferred Khan there and not that person? Why does IDAC involve itself in those things? IDAC does not constitute panels that interview candidates in crime intelligence. Why does IDAC go to court and say to court, I want warrants of arrest issued because I'm not happy that in that panel that general was there and General Khan was not there? Why is it the business of IDAC?
Thank you, Chair. Thank you, Commissioner. The panel has been approved by head office, but the recommendation of that particular panel started with General Kumalo. So it's one of the inferences drawn.
How can you draw an inference when the prescripts give him the power to constitute a panel? What inference can you ever draw from the constitution of a panel? If the prescript says the power lies with Kumalo to constitute his panel, what inference is there to draw when he does exactly that which the prescript does? And in this case, you're not drawing an inference of anything. There are no facts on which you draw an inference that is problematic. Yes. You actually say, well, he should not have included, I think it's Gabela, he should have put in other crime intelligence officers. Yes. For example, General Khan, quite interestingly, you say, for example, General Khan. The question is, what does IDAC care that General Kumalo has recommended a panel, which his superior General Sibiya has approved, and you don't arrest General Sibiya for approving. General Nkua approves. You do not arrest them. You don't include them in your list of the people who did wrong about constituting the panel. The bottom line is, why is it IDAC's business when General Kumalo constitutes a panel that he is allowed to do by the prescript, which doesn't say it must be constituted by people from crime intelligence? It doesn't. So you make up your law or your rules or your policy and say there should have been only people from crime intelligence because that's a sensitive area. Where do you, what's your standing to prescribe that? And I would like you to answer that question. Commissioner Kumalo asked the question, what is your business in how SAPS prescripts, because this is provided by prescript, in what SAPS prescripts allow, and in this case was complied with, superiors approved. What is IDAC's business and interest in constituting SAPS panels? You can answer if you have an answer.
Thank you. Thank you.
Post number, you provide the number. At sub 1, you start by mentioning that TSS is a National Covert Operations Unit located in CI and is highly specialized. At sub 2, you say it was advertised on that particular date. Then you reference the national instruction at 12.4, item 4. You state the selection panel was chosen by accused 1, and it comprised of accused 1 as the chairperson, and the other panel members were accused 2, 3, 4, and 5. You see that?
Correct.
That is incorrect.
Correct.
That is incorrect. It wasn't chosen by General Kumalo. The panel here. You are suggesting that the panel that interviewed these candidates was chosen by General Kumalo. We have just established that it was recommended, perhaps by General Kumalo, for approval by the higher authorities and was approved. So that statement there is misleading. Will you accept that?
In my 12.4, the panel was chosen by accused 1. It's chosen by accused 1.
Okay.
Meaning that comes from the recommendation part of it.
Oh.
Yes.
You just omitted.
That was chosen by General Kumalo, but it still has to be approved by head office, which is the prescripts, as Commissioner Molloy explained. The panel was chosen by him at that level.
Okay.
But do you accept that it's misleading to have put it that way? Because a reader of that paragraph understands only that General Kumalo constituted this panel and he presided over it. That's a misleading statement, because if you had intended to be fully transparent about it, you would have said it was recommended and it was approved by his superiors. You didn't. It's a misleading statement. Do you accept that?
Noted, Commissioner.
And just to confirm, nowhere in this charge sheet do you speak of that panel being approved. That somehow is omitted in this charge sheet.
Can you
Oversight, perhaps, or whatever. I just want to establish as a fact that it is not there. They are
Not make them up. They don't come from him. They come from you as the IO.
Noted, Commissioner.
Thank you, Commissioner Kumalo. And I drew you to this document because you were a part of its creation. Alternatively, you approved it, and I say that in a very, not in the strictest sense, but you made common cause with it, enough to present it to a court of law in support of your application or an application based on an affidavit you deposed to for the issue of the warrants. So you have to accept responsibility for this, whether in its creation or presenting to court to argue for the issue of the warrants. There can't be a challenge. It's your affidavit. It's your annexure. Can you accept that?
Noted, Counsel.
No, noted is not very helpful because I don't know if you agree, you disagree, or Swiss air, I don't know. Do you take some level of responsibility for the facts placed before the court?
I say noted, Commissioner. And the reason why I say noted is that I still got to appear with the same affidavit before a criminal court. So I'm saying noted.
So if you are still to appear, it's already on record. You can't change.
We want to know where you stand on the facts, Colonel.
Yes, I'm saying noted on it, Chair, and that's the
That sounds evasive.
Chair?
That sounds evasive.
Chair, I'm not going to take it further than to just say noted.
I'm going to ask the question differently, and hopefully we get an answer. In the IDAC, when you have told us that the head, but it's not just him. So why did you not mention any other name? And I'll say to you before you answer that the impression you have created with specifying him is that this may well have been about his exclusion. You were punting for him. Taking issue in 12.5 is in fact about the exclusion of General Khan in particular from the panel, from the interviewing panel. That's the impression this paragraph creates, because you cover it by mentioning that there were other 6 major generals that could have been chosen within crime intelligence, but curiously, it's General Khan that you mentioned. And what we know about him is he was in the previous panel, of the previous panel that did not succeed in filling this post. We know he was there. Now he's not in, and you take issue and you give him as an example. And it gives the impression that, in fact, the complaint in 12.5 is about him and not any other crime intelligence officer that could have been part of the panel. What do you say to that?
Thank you, Chair, Commissioners. Let me first start by General Khan. As of today, and everything that is surrounded General Khan and his activities, his names will stand out now, no matter where it gets mentioned. It poses a question mark there. When I put this in, the other provincial heads, including General Khan, who sits at head office right next door to the panel, that's what I wanted to say. He is there. So it was including him there is not to say, but him particularly in that instance. And at that moment in time, mentioning this name meant nothing, but mentioning it now, and any way in our investigations, raises that, stands out. So I take it from there, Commissioner Beloy.
No, Colonel, I don't ask, it's your answer, but I have to leave you with this. I don't accept that mentioning him here meant nothing. I don't. It's curious that it's him specifically that you mention. So I hear your answer. You've given your answer. It's your best answer, but I don't accept that it was as innocent as you want us to believe.
Noted, Commissioner, and noted that inferences can be drawn for that. I acknowledge that.
Maybe related to this, sorry, Mr. Let me just finish off.
Is it an arithmetic exercise? They're adding up, they ended up with 15 when it ought to have been 12. Is that the issue? Or they were not properly marked, in a sense that considering the response given, the mark allocated was not proper?
The marks allocated, and when you look at the written test, when you look at Mokwele's one in comparison with Bapela and
Van
Vuren, who are in the post, who have been there for a very long time, writing those written assessments and what they've written there. And when you look at Mokwele, who does not have any police background or anything of that sort, but the question is given to her where she draws a police document with how you would address it as normal, structure it out. She's a civilian, does not know about how the police letterhead goes. And that was the one thing that we looked at. But the marks allocated day and the final marks that were allocated in the end of the day, and in comparison with the candidates, the knowledge, the experience, and from the specific environment, we start with Bapela. The final mark of Bapela was 40%. Bapela has been there for a considerable amount of time, acted in the post, and up until recently, this post that Mokwele is, he was acting in the post. So immediately after Mokwele was moved laterally, Bapela was appointed to act in that post until further notice. He is a person that has failed the interview, 40%. Then you have Van Vuren, who's been in that environment for many years, traveled overseas, given lectures. He knows the whole setup, a technical support unit, inside out. He got 49%. 49%. So just by looking at the allocation of the marks, it brought about questions. This thing has been manipulated.
Could get higher scores than them and could be appointed.
It looks glaringly abnormal, sir. And I stand by that.
No, it may look abnormal. We are back to that question. What is IDAC's business and mandate to want to prescribe an advert to SAPS? Because that's what you're doing with what you've just said now. You say, well, this looks abnormal. It should not have included policing, public administration management law. It should not, criminology. It should not have included any of those. The question is, what in your mandate authorizes you to make that kind of pronouncement and flag it as a problem?
The more you explain yourself, Colonel, the more all of this sounds like meddling in an HR matter. Please respond to Commissioner Baloyi.
And meddling in an HR matter of another institution over which you have no statutory authority to comment on. You have no authority to comment on SAPS's advert for this position. You don't. It's not your place to say, yes, they should not have included management and law and public administration. It's not your place to say they should not have advertised outside. So you should not be, as sitting there, you should never be saying, oh, it's an abnormality. Because when you do that, it means you know the normal. And the normal that you say should have been in this advert. And then it brings us directly to, but...
Because during the course of the interview...
No, Colonel. No, come on.
Colonel, for him to view the file, you must give it to him. If you are interviewing him and it's with you, he can't view it. So you must have given it to him to view it, for him to form that view in that paragraph.
Yes, sir. During the course of the interview.
Was that we are seeking to obtain a statement from a witness. Is it proper to give him that file for him to prepare a witness statement in circumstances where you intend to proffer criminal charges against senior members of crime intelligence? Do you consider that appropriate to do?
Counsel, Commissioner, Chair, during the course of the interview, whilst I was busy with it, I had the file open and I was going through the file during the course of the interview. Yes, I acknowledge what you were saying, that is it proper for him to view the file?
No. You just conceded to the commissioners that, yes, actually you gave him the file. So you gave him access and permission to view that file. So we are past that now. I'm asking as to the propriety of that decision and conduct on your part. Do you consider that proper? In circumstances where you are seeking him to provide you with a witness statement for potential criminal charges to be brought against senior members within the institution you're investigating. It's either you consider it proper or it's not proper. There's nothing to debate. If you're happy with it, I'll move on.
Chair, Commissioner, at that moment in time, I did not consider that.
You did not?
I did not consider that.
Okay, now that we are here, in retrospect, do you think it was proper for you to have done that?
No, I don't think it was. I mean, I'm sitting there and I'm interviewing him and I'm listening to him and taking an affidavit and then referring to the file. So I cannot see the reason why you say that I would have done something wrong by showing him the file.
Because you are influencing the content of his witness statement. So he's no longer deposing to an affidavit on facts he knows something about. You are feeding him the information and thereby influencing what goes into his witness statement. That is the problem. Did you ever give any other witness this file to say, these are the contents of the file, now go give me?
That is improper.
Commissioners, we're not talking about Mrs. Mokwele doing something irregular. We're talking about Brigadier Mokwele, who is the head of the vetting system that should have known better.
With this, you have one of your charges. The charge against Ngube is on this issue is Ngube and Mokwele. So according to you, Mokwele has done something wrong by being put on the, what do you call it? Inkwazi.
On the service provider.
Yeah, you say she's done something wrong.
Yes.
And yet I understand you now to be saying, yeah, it's a Ngube problem. Why would you charge her with this?
All that we have there, Commissioners, we don't know what was the communication between Mokwele and Ngube. But what we know, we have a letter from Ngube where she's saying that Mrs. Mokwele has been registered on the e-vetting system. And Mrs. Mokwele herself knows that's not the fact. She's registered on another Inkwazi system. But be that as it may, both of them are charged according to the charge sheet. Is that what you say?
In there. In fact, when I say it's petty, at best it's pettiness. But it suggests something much more sinister, because you do not have facts that implicate her in being on the Inkwazi platform, and yet vetting platform.
Yes.
Yeah, you don't implicate her in the Ngube letter, because that letter says nothing about her. And if you want to say, oh, it is that letter that makes me include her with this charge, then I'm going to say, well, you seem to be prepared to suck up facts out of thin air which are not supported by anything. If you say this letter implicates her, the letter doesn't on its terms. It makes absolutely no reference to her.
Yes.
You know she could not have been on the e-vetting platform, according to you, because she doesn't have a commander, she doesn't have a PESAL number. She gets put onto the service provider platform by somebody else. You include that against her. You make her complicit. You say, that's your wedding. You say she was in a conspiracy. She colluded with Ngube in a document that is seeking to get you an arrest warrant against her. So it's not just an affidavit that's lying around in your office. You make those allegations in a charge sheet that you're going to present when she applies for bail. The court sees, the magistrate sees a charge sheet at that point that says she colluded with Brigadier Ngube to be placed on this platform when you have absolutely zero facts that justify that. That's a problem. It's a serious problem, Kelden. It is. You had no facts whatsoever. You made it up. You made it up to include her in this charge. And that's deeply problematic. In fact, it speaks to, until it's explained properly and satisfactorily why you included her on this charge, it speaks to an abuse of your power and authority to victimize an innocent person, at least on this charge, when you have no facts about it. You can comment if you want to.
Thank you, Commissioner. I note you say I included her on the charge sheet. I'm at pains at that, It's my affidavit, my investigation, my affidavit scheme. I don't draft the charge sheets and say who must be charged for, who must be charged, what charge is there. I don't. That is at the prosecutor's door. They make that determination. So
I'm prepared to accept that, and what you're doing with that answer, in fact, what that answer does is it causes us to call the prosecutor to come and explain how these charges.
The sting in the complaint.
The vetting process hadn't started. What she did to get through and comply with the letter, she could not register on the e-vetting system because she has no force number and no commander. Right?
But then, Colonel, all that means is that the letter of 24 July was disadvantaging her, or the letter before this one, because that letter said, before you come to the interviews, bring your IDs and other things, and then submit your vetting application through the e-vetting system. That was not required. It could have been done within 6 months after her appointment.
It's correct.
So the fact that that letter was sent to her means it was disadvantaging her because it was requiring her to go through something which was actually not required.
Chair, Commissioners, exactly so.
So then why would you charge her for that? That she's being disadvantaged. She's not being benefited by that thing. She's being disadvantaged. Why would that then constitute a charge or an offense by her? If she's being required to do something that she's not even supposed to do, because vetting is required within 6 months of appointment, not before you come for an interview.
Exactly, Chair. As I said initially to Commissioner Beloy, in my response to her, I do not draft the charges.
And we've been there before that.
Yes.
The prosecutor gets all that information from your affidavit. Don't they say to you, I've looked at everything, I've looked at the docket, I've looked at your affidavit, I've now drafted a charge sheet. Have a look at it and confirm that I've recorded the facts correctly. Don't they do that?
That does not happen on this occasion, Chair.
But
if I say that it had happened, then I'll be lying. It did not.
Does it happen on other occasions?
Sorry, sir?
Does it happen on other occasions?
No, Chair, not that I could recall.
So the IO does not have sight of the charge sheet before it's finalized?
I think my concern is deeper than that. I do not, with respect, accept your explanation, Colonel. You caused for somebody to be arrested, somebody who, on your own fact, was not complicit in the crime that you describe in the charge sheet. But because of your affidavit and the way the charge sheet is drafted, you caused for her arrest. That's irresponsible in the extreme. That's abuse of power. And it is not enough for you to say noted. No, Colonel, I don't accept that. I worry for the rest of the citizenry. Must I? I don't accept your answer. Resulting in her getting a security clearance she was not qualified to get. Where does anyone get the idea that as at the time this charge sheet was drafted, Mrs. Mukwele had a security clearance?
When I look at this paragraph now in hindsight,
yes,
it is the vetting application.
Okay. What about the vetting application?
That is to get it registered on the system.
Okay, so the yes, part that resulting in her getting a security clearance, that's yes, factually not incorrect because she did not get a vetting cleared. No. Okay. And in fact, we know that she was, having been recommended, she had 6 months to get through the vetting process.
Yes.
So her appointment was conditional, amongst others, yes, on her being cleared, but for that she had 6 months.
That's correct.
Okay. I will
Then she was charged before that 6 months even expired.
Chair.
She was arrested before that 6 months even expired.
That's correct, Chair.
I would like to move to a very short topic, which is my last topic.
Sorry, can I?
Absolutely.
I just want to clarify.
Charge and IDAC, sits in the back. But reading this letter is from the Acting Director of Public Prosecutions, Gauteng Division, Pretoria, and it's addressed to Advocate Johnson, Director at IDAC. And it says, your correspondence dated 24 June 2025 in connection with the above matter refers, I have read the consultation note as well as the draft charge sheet attached to the above correspondence. Now that suggests to me that IDAC put together the draft charge sheet and not the other way around. And then look at the last paragraph. Having considered the contents of all this documentation, that would include the draft charge sheet, I'm satisfied that a prima facie case has been made out against the accused and the suspects, and I concur with your decision to charge. So IDAC's decision to charge them on the offenses as set out in the charge. So isn't that how it happened and not the other way around?
Commissioner, this is a consultation note that is between the head of office, the ID, and the Director of Public Prosecutions. I have no role in this.
But do you doubt the accuracy of this document? It doesn't reflect what happened.
I'm not saying I doubt the accuracy of the document. What I'm basically saying is that this is a communique between the head of IDAC management and the Director of Public Prosecutions. If there's something specific that you want me to say on it.
And I'm saying it sets out what happened from the 24th, and it says there's a consultation note as well as a draft charge sheet attached to the above correspondence. That's the correspondence of 24 June 2025. And then it says, having considered all the documents, I concur with your decision to charge on the offenses. So the decision was by IDAC to charge, and also the draft charge sheet was prepared by IDAC.
Yes.
And the Acting Director of Public Prosecutions looked at all of those and said, I agree with IDAC.
Chair, Commissioners, no, thank you. I understand what you're saying. Yes, it is IDAC that's presenting this to the Director of Public Prosecutions, not the other way around.
Including the draft charge sheet.
Yes, including the judge. It's not done by the Director of Public Prosecution. It's, from the way I understand this and the way I've learned it in the office, is that we want to prosecute this in your province. And there's the consultation note together with that. That's how I understand.
So your earlier evidence to distance yourself from the draft charge sheet, that cannot hold, because the draft charge sheet comes from the investigators, which is IDAC.
Okay.
Leave the court to act as a neutral arbiter of matters raised. And then I'll invite us to go to 2962, where at 19.17, the court concludes, or the judge concludes, I'm unable to find any judicial basis on the evidence and submissions before the court for the bail condition that was imposed. In exercising his judicial discretion, the magistrate did not confine his assessment to the facts presented before the court. And in upholding the appeal, the judge concludes at paragraph 20.1, the court's decision to impose the bail condition appealed against was made without identifying any supporting facts. It is arbitrary and incorrect and does not reflect a proper exercise of judicial discretion. In summary, the High Court concluded that that bail condition, which is the only condition that the three were appealing against, that they should not enter any office of crime intelligence until the trial is disposed of, was not requested by the prosecutor. It had no basis and the magistrate did not have a power to impose such a condition. You understand that?
That's understood.
May have on same left at the premises of any crime intelligence officer. The sum effect of it is because they are prohibited from entering any crime intelligence facility. Mr. Brian Padayachee, that is yourself, correct?
That's correct, Chair.
Will assist the accused to collect any items they have left in their offices, whether personal or of whatever nature, at these crime intelligence offices. If this condition was never requested and the magistrate imposed it nonetheless, why does the magistrate pick on you to be the person to collect anything that these accused require? How do we land there? Are you able to shed some light? You say you didn't personally request it from the magistrate. You confirm that the prosecutor did not put it to the magistrate in open court. Does the magistrate know you personally? Do you know the magistrate personally?
I think it was my affidavit or something. My name was mentioned there. It's a while back. I'm trying to recall. But when I was standing next to the prosecutor, which is quite close to the bench, as the way I can see where he put it there is I, as the investigating officer, if they want to go to the office, they have to contact me before they go there to their respective offices. So that would have flowed from that bail condition that was set up about the premises. But I left court at that time. And it was only at the later stage that I found that no, this bail condition was put in as they're not allowed. So I, as the investigating officer, that is how the second part we're looking at four Chair commissioners came in.
So we have a situation where
processes during the course of it. So that's where he probably picked it up from. But I know that the prosecutor didn't mention it. Thank you.
Yes, Commissioner.
Why did you want this bail condition that they must not go to the office? That you say you didn't discuss with the magistrate,
yes.
Somehow he comes to know about it. Why did you want that condition?
Yes, Commissioner. As I indicated, we were busy with investigations on the Secret Service Fund, documents, etc.
But this matter had nothing to do with the secret fund. It had absolutely nothing to do with it. This case, this Mukwele matter, it was about the recruitment and appointment of Brigadier Mukwele.
Yes.
Why are you introducing other cases that under this bail condition?
Yes.
Yes, you may.
Thank you, Commissioner. I think it was mentioned during the course of the proceedings there that the accused before court are also implicated in other matters that we are investigating.
Yes.
And during that process of not just the Mukwele case, but the other cases that we're investigating, I'm digging into my memory that was said there, that we consider the crime intelligence officers, especially where the Secret Service Fund was, as crime scenes.
So you were getting a bail condition, or you were asking for a bail condition that in fact has absolutely nothing to do with the matter that is before this magistrate. It has to do with other cases where you must justify bail or other bail conditions in other investigations that you are still conducting. You are.
Thank you, Chair, Commissioners. I see the SAPS regulation and the manner in which they do, and each case is decided on its own merits. However, ever since I've been at IDAC, with regards to matters that's being investigated, when the matter is serious, it's a serious charge. I know I'm mentioning Schedule 5, the other circumstances with regards to this firearm, witnesses, etc. The normal thing is that we apply for J50s. And as far as I've known, or the operations that I've been involved in myself, is that the J50 that we have is not taken to the person's house and where they're being arrested. They're brought to the station and they are processed there. So all that I can say is that, Commissioner, but then the question will be, why apply for a warrant then? The warrant is there. We have it in case there is something that where the person doesn't report or the person decides he's going to now evade justice or whatever else is there. Thank you.
Well, I think the correct thing to say, to express how IDAC does things, is to say that as a matter of course, we apply for warrants and we arrest them at the police station, because that's what you're saying. We call them to come to the police station, and when they arrive, we arrest them. So your modus is an arrest. We are charging this person, we arrest. That's how IDAC operates.
That you are correct.
Okay, thank you. Thank you, Mr.